faces and names. All right. All right, all right, all right, all right. Three all rights is Dazed and Confused. Four all rights is Hey Ya by Outkast. All right, let's try something else. I think I've always wanted to try this one, and today I'm feeling particularly bold. If you're happy and you know it, clap your hands. If you're happy and you know it, clap your hands. If you're happy and you know it and you really want to show it. If you're happy and you know it, clap your hands. Ooh. I like this. I like this. Good morning, everyone. Morning, bright-eyed, bushy-tailed. It is good to be back in Indianapolis. It's good to be back on stage. It's good to be back here with all of you. This room has a lot of history in it. This is where I gave my first presentation as part of the auditor's office at the time, the comptroller's office here. At the time, Dan Baston was sitting there. Tara Klutz was sitting there. And I felt like I was being fact-checked by two robots in real time. As I'm presenting, I'm looking over to see if they're nodding. No, that's not the way that works. It has always been a challenge presenting to such an intelligent room with so much background in the field that they are able to provide real-time feedback on the information that's coming in. But that's not my favorite presentation that I gave here. About 6 years ago, I had double duty. And so I gave a presentation up in Middlebury, Indiana, and then left before lunch, before I could get some of the pie that they had sitting on tables, because I had a presentation the same day in this room that afternoon. And so get in the car and drive down to Indianapolis, and I'm practicing the presentation, and I'm thinking about what I'm going to say, and I'm walk into the room, and it's like a crypt. Whoever had presented before had delivered some pretty bad news, and the audience is just about turned on it, and that's the room that I walked into with a big smile on my face, no idea what I was walking into. So we have just established that you are happy and you know it. We did it with our hands, and so we have got an energetic crowd, and we are going to work through our presentation today. All right. Very easy presentation. We only have 30 minutes before I turn it over to State Board of Accounts. And so I do want to cover a couple of topics that we're going to burn through pretty quickly, open it up for some questions and answers, and then once we are worked through that one, we'll be able to turn it over to Board of Accounts to take us through the presentation right before lunching. Okay. No slides today. Just vibes. You'll just hang out with us for a little bit, and we'll work our way through the three topics. The first one is the easy one. The Comptroller's Office doesn't present on legislation very often, and so when we're presenting on legislation, it tells us that that there is an important one coming. House Enrolled Act 1210, Section 88. You're going to hear more about this from Board of Accounts, both this session and in the fall. You're going to get more guidance from the Department of Local Government Finance, because this particular piece of legislation is going to impact them before it impacts our office. So let me cover some of the key pieces of it. But the first piece of information, and the one that's most important, is the effective date. The effective date for this particular section is January 1 of 2027, which is important to say. It's not going to impact this settlement. It's not going to impact the December settlement. But going into next year's cycle, it's important that we are starting to prepare for the change that this is ultimately going to lead to. Now, we've got a memo written, drafted. It's prepared. We plan on releasing it after conference. Wanted to talk about it first, and then you'll get the documentation that goes along with it. It'll cover the language, it'll cover the expectations, but what I'm hoping to do for the next few moments here is give you some context of what we are looking at doing. In essence, what Section 88 is doing is creating more flexibility. A year ago, there was legislation that changed the way the FIT and CVET worked. Instead of this auditor calculated level where you were doing the calculations and then sending out to the locals, FIT and CVET took the same recipients, took the same dollar amounts, but the county auditors effectively just passing that through, like we presented on last year, and like Comptroller Nishala spoke about earlier. excise is moving in that same direction. So instead of the county auditor going through a fund level calculation, instead of the auditor going through a fund level calculation and distributing at the fund level, during the settlement, you will first do the fund level calculation, aggregate it together, and then hand off the full excise amount to the locals. Now, the legislation kind of caught us off guard, but I think one of the things that we were able to do while working closely with the representatives was to delay the implementation, which is hence the January 1. Gives us both, won't impact both the budgets, the settlement process that we are getting ready to go through, gives us some time to work with the counties, to work with your tax and billing vendors, to make sure that we've got clean expectations on the forms, the formats, the times, the guidance that we'll be releasing. It'll also give us a chance to work with the recipients so that they are aware that this change is coming again, not this cycle, but the next. Now, in terms of some of the impacts we're going to be looking at here, when we're talking about FIT and CVET combined, we're looking at about $100 million. When we start talking about excise, and we start talking about excise statewide, we're looking at something that is rapidly approaching a $600 million annual figure. So there's going to be much more impact. If the ultimate goal of the legislation was flexibility, this will accomplish that. We've known for a long time that excise has been following the footsteps that are really being blazed by the property tax rates / levies, depending on how we want to look at it. This will give each unit a lot more flexibility in being able to determine individual pots of money and what fund or funds that unit wants that money to go to, independent of the actual tax rates or where their property taxes are going. So on one hand, this will create that flexibility. On the other hand, and the comptroller's interest in this particular calculation is its impact on the settlements. We know that during the settlement, excise is one of the things that we sample. Using information provided by the Department of Local Government Finance, we want to make sure that the correct rates are loaded into the tax and billing system before that money ends up moving out the door. This change is likely to impact the calculations we're doing on our side, not the validations, just we're going to need to expand it. Generally speaking, we test about 5 taxing districts per county per settlement, and where possible, if there are enough taxing districts in the county, we'll do different ones in the spring than the ones that we'll do in the fall. In order to validate that the units are receiving ultimately the correct totals, we are going to look at expanding the number of taxing districts that we are testing. First, to calculate that it's being done at a fund level, and then second, to make sure it's being done at the aggregated level. So, importantly, this change is not for this settlement cycle, but it's important that we get this on the radar. Don't change too soon. More guidance is coming out from our office, from DLGF and Board of Accounts, but I wanted to make sure this was on your radar about the importance of a change like this one. Memo out later this week that will highlight the section, we'll draw attention to it. What's funny is that Section 88 might be 16 lines long. It is the shortest piece of legislation we've seen in quite some time, but the impact is going to be a little bit disproportionate and when we start to consider all the changes we'll be looking at. Okay, so that's number one. I wanted to talk about 1210. The second thing I wanted to look at are settlement updates. Right? So let's talk a little bit about the upcoming settlement. First off, I would like to recognize Owen County. Where are they? They are definitely putting pressure on the comptroller's office. They submitted their settlement yesterday in the afternoon. And so when we leave, oh, absolutely. So the settlement season has absolutely and effectively started. We work closely with your tax and billing vendors during this time. Some will provide us a schedule of their planned county visits so that we can plan accordingly. Largely there's no change in this upcoming cycle, right? The forms, the formats, the timing, the calculations, we're going to go through a very similar process that we've historically gone through, with one key exception that we'll be looking at here in just a moment. So we are ready when you are. When I leave here later, we'll go back and see if that settlement has made it through the Crow review. What I'm hoping is that we'll be able to deliver good news this afternoon that they were both the first county to submit and the first county to receive pre-approval. Okay. So it's mostly the same process that we went through last year, but there's one key change. As a couple of you have found out already, The fines and fees section has always been a challenging part of the settlement process. For those of you that have looked online, you'll notice that the spreadsheet that we generated last year that mirrored the tool that we use for the individual validation is not available on the comptroller's website. We are phasing a fund level review of fines and fees out of the settlement process. That is not a decision that, so there's a couple things there. One, it's not a decision that we came through lightly, right? I think that it's important that the state reviews those numbers for a dozen reasons, including every year there's a handful of counties that will either end up submitting too much and requesting a refund. This is important that it is locally collected taxes that are remitted to the state. But after years of experimenting with different ways to validate it, the historical averages, longer historical averages, not just 1 year, but 5 years. There are certain fines and fees that we just expect every county to remit, like the infractions, right? We simply do not have a tool. We do not have a way of guessing what that number is supposed to be. And so after years of trying, we're ultimately going to move in the other direction. Now, with this change, I want to make it clear that there's not a statutory change here. We're not presenting on the law change and this is no longer a requirement. This is more of a procedural change on our end. You still need to collect the information. You still need to report the information through the settlement. The remittance of fines and fees is still a necessary prerequisite to approval from our office. We will ask questions if you leave that section blank. We will hold off on approving the settlement if that information is not included. But the questions about back and forth, about increases and decreases, we're going to assume that all of that is working perfectly on your end, and the amount of money reported first and then remitted to our office contains everything that it needs to, and we'll look for that check in the mail, look for that payment electronically in our account as we go through the settlement review process. So while it is still important, while the requirement is still there, just expect in this upcoming settlement there'll be fewer questions relating to the fines and fees, but the same amount of questions as we relate to the other parts of the settlement and the excise review that we've historically gone through. So no longer a required form. We're not going to post it anymore. Hope that you've got the tools and the controls in place to be able to review that information before it comes to us. Still report it on in section C of the 105, and then you'll remit the money at the end of the settlement process. Well, I was kind of hoping that'd be more explosive, but subdued is a choice. You know, it's easy, right? I mean, if we're looking at $600 million of excise annually, and this year probably $10.5 billion worth of property taxes, it's hard to hold up a $100 million settlement because overweight vehicles went up by $200. So I think it's the right move that we're ultimately going through. Apologies it took us so long to come to that conclusion, but perhaps this will cut down the numbers of back and forths. We'll be able to get through the settlement. We'll be able to get through the meat of the settlement a whole lot faster than we have in the past. Okay. 2 more notes, and then I don't think I'm going to make it the full 30 minutes. And so if there aren't a ton of questions after I cover these next 2, Tony has volunteered to show us that dancing that he was doing at that wedding recently. No? Yeah. You put it up on the screen. Okay. So 2 more notes wanted to do. When Elise presented a moment ago, she took us through the transparency portal. At the resource table that we have in the back, we have QR codes, right? So if you wanted easy access to, and if we were looking for the website of how to make it to that page, if you stop by our resource table, you can either scan the QR code or we've got handouts that will explain what the federal the dashboard for federal expenditures covers, easy access through our resource table in the back. Okay. Last thing I wanted to cover is the roundtable update. Elise talked about it a moment ago about this transition to short form content, and this is something that I've been passionate about for a while, and I'm happy to finally get an opportunity to look at it. Oftentimes when we're doing presentations, we're presenting to the amount of time we have, not necessarily to the topic that we are addressing. This pivot to these shorter videos means that when we need to present on just one topic, we'll be able to do, she said 3 minutes, I'm hoping for 7, right? But not 60 minutes, right? Just like very focused introduction to a particular topic. What we hope that will open the door for is we can post those, we can record, post those presentations, make them available 24 hours, right? So that they are an additional support from our office to be able to introduce these topics, to be able to share these topics, to be able to refresh on these topics without having to jump to slide 76, right? Just these easily digestible pieces that you can take a look at. It will also open up more of our presentation time to allow us to move into topics we haven't historically gotten into. So by building a library on the comptroller's website, or accessible through the comptroller's website, we hope to be able to supplement what we're putting into the memos, right? The memos will still be part of the process. Sometimes you need all those pieces working together, the code citations and calculations, but to be able to add to those with a little bit more support. The things that don't type out well, but are meaningful for understanding sort of the distributions, the calculations, the layouts, or the forms that we'll be looking at. We have committed to a half a dozen of those before the end of the year. The roundtable that was recognized earlier, we'll get a chance to see those later this fall before we start hopefully presenting on the presentations that we've recorded and posting them on our website. So more information to come. Definitely opens the floodgates for things that we can cover, or things that we can start to attempt to put good information into the world, but without having to commit 60-minute live in-person webinars. Just more of, we'll film it, we'll record it, we'll post it, and then we will start to build a library and then share that information with you and your staff so that you can do quick little hits into specific topics that we want to share more information about. Okay, last one. Just one person that I hope everyone in this room meets. In the front is Tanya Armstrong, the Assistant Accounting and Reporting Director with the Comptroller's Office. If we were looking for a strong left hand, it is Tanya Armstrong. She helps, she's been at the Comptroller's Office for 11 years in the office and is starting to spend more time on the local government side, learning about the remittances, learning about the distributions. At some point, maybe at the next conference, she'll be the one behind the microphone here presenting to each one of you. So if you have got advice about how you, if you've got advice for someone who's getting into local government, if you have, if you would like to share your story on how you got into local government, Tanya will be here through about 2 o'clock today. Stop in, say hello. Okay, that is all I have. But before I turn it over to Board of Accounts, any questions about settlement related? We've got 1, 2. We got 2 in the back.
Regarding the fines and fees, we don't have to put any explanation of increase or decrease anymore. We just put the amounts and that's it.
Just the amounts?
Perfect.
And that's it. No, but what you were describing is the review that you have historically always done before you've ever sent it to us. We know that's been done. We don't need to proof it. We don't need to check it. We don't need to ask you, are you sure? This is the work that has always happened before us. This is the work that will continue to happen after this change. Just put it in section C, send it in. No questions from us. Unless you leave it blank. Then you'll get questions. Other than that, that's maybe the only line that we are looking at for the upcoming cycle.
Hey Fred, mine's not necessarily a question, but more of just a tiny tweak to your checklist that we submit. While I was going through settlement, if you can maybe color code, because I know you're streamlining that checklist, so you've got groups that are June settlement that apply, and then applicable December settlement check marks. If you can color code those, or gray or white or however, just so that it brings the attention, because as you're going through and matching, and then you're like, oh, you start to hit complete and you're like, oh, I'm in December settlement and not June settlement on the checklist.
A very, very easy upgrade. The one thing we will need to solve on our end is ADA compliance. When as we post things on our website, Excel can be it'll let you turn it any color you want to, right? But as we try to make our website compliant, we'll find a way to be able to differentiate between December and June. And so that is, thank you for bringing it up. There are 2 changes, maybe there are more changes than I realized, to the settlement. The first one is, instead of having a spring checklist and a fall checklist, we're trying to streamline that one, just one document, right? So instead of figuring out which one is which, it lets us only post a single document. It lets us control the flow of it. It's fewer updates for us, but it means there are other ways that we should be able to differentiate between which documents are spring only and which ones are fall only. That change also applies to the settlement manual that we're posting. So instead of a spring manual and a December manual, one manual. That's all we need. But with sections that have been earmarked as December only. This seems like an easy upgrade. Feels like we should be able to get that upgrade made to the version that we have posted online. So because of that question, most of you will see a color-coded version, and have no idea what she was talking about. Question from the new person in the front. And I'm hoping that the next one is the person on that side of the room. We'll make sure that Stacy gets her exercise.
Just a comment, because I've already had this question about the fines and fees. Last year, we had several counties that wanted to go ahead and remit the fines and fees, even though they haven't done settlement yet. Yes, you can still do that. We do have a separate form that you could use, because obviously we need to know where to deposit the money. So if you need that, just shoot us an email and we'll make sure you get that. Okay?
All right, looking at this side. Going once, going twice. Excellent. All right, be around into the early part of the afternoon if you want to keep the conversation going. Otherwise, Board of Accounts, floor is yours.
Okay, I think that looks right, which is a small victory in and of itself. For those of you who don't remember me or have not had the pleasure of meeting me yet, my name is Mike Rooker. As Paul mentioned earlier this morning, I am Stacy's new partner, so she's stuck with me now from at these conferences going forward. I know everybody was used to Ricky, and I know I can't replace Ricky, but I will do my best Ricky impression for all of you. I did get to speak with most of you, I think, last fall in October at the auditors conference briefly. I think I gave you a bunch of bad news about auditors' powers and duties. At least I think I made some people very angry about some of the case law that's out there related to auditors. I'm actually mostly joking, but so I did get a chance to meet most of you, and hopefully I've had a chance to interact with lots of you either through email or on the phone. If not, there's a good chance we'll be talking going forward when issues come up that relate to the State Board of Accounts and what you all do. Today, we're going to talk about something that everybody loves to talk about. It's not going to be settlement updates like Fred talked about, and I don't have any good news for you like Fred had, but it is going to be opioid settlements, so also settlement related. This is an issue that we are getting a lot of questions about. I think Stacy would confirm that. And it's not just counties, it's cities and towns as well. They get opioid distributions, and this is a very hot topic, how to spend your restricted opioid funds and what's permissible. So we wanted to give a lot of time for this presentation because we have gotten a lot of questions about it. I have some content for you, but I don't know that it's going to fill the full hour. So if you have questions, if you have things that you want to bring up that you think might be relevant, please feel free to raise your hand and interrupt at any point, or save it for the end and bring up any issues that are coming up for you. Okay, so let's start. What are the opioid settlements? Well, the opioid settlements are a series of legally binding settlement agreements following what I would describe as really complex litigation, totaling over $50 billion in total settlements that are going to be awarded to state and local governments. So this is a big pot of money related to some claims related to negligence and public nuisance that were filed by state and local governments. This type of litigation, we lawyers, we call it multi-district litigation, MDL litigation, which is really complex litigation. It's not a class action suit. It's a little bit different than that. There were so many different lawsuits that were filed in federal courts all around the country that what ended up happening is all of those lawsuits were consolidated into a single district in eastern Ohio, so that in an effort to sort of reach a fair settlement and a fair resolution, all of the parties to the suit could try to resolve it in a single forum. Sort of the theories behind these claims that led to the settlement were, number one, negligence. So in a lawyer's mind, right, negligence is the failure to exercise the standard of care that you would reasonably expect somebody to exercise. So when it came to opioid manufacturers and distributors, the claim was that they didn't exercise reasonable care in protecting the public from the potential harm that those substances could cause. The other claim was it was in public nuisance, which, again, that's an action that interferes with the rights, health, and safety or comfort of the general public. So usually when we think about something like a public nuisance, we're thinking about like a building that is attracting various problems because people are hanging out in there and causing problems. So that was kind of a creative legal theory, but it's one that ultimately led to the resolution of the opioid cases and the opioid lawsuits. How did we get here? So I used to work in local government for 14 years before I came to the State Board of Accounts. I worked in Monroe County for the city of Bloomington, so I was on the city side, not the county side. And I know sometime right around 2018, we had all these law firms from Indianapolis that started sending us emails and calling us up and reaching out to us saying, hey, we think that local governments have these claims for the opioid epidemic and all of the expenses that have been realized by cities and towns and counties around Indiana, and we would like to represent you in a lawsuit. So along with a lot of other units of local government, not just in Indiana, but from around the country, we filed a lawsuit, and we actually did ours jointly with Monroe County. So we had meetings together with Monroe County, the city of Bloomington did, and we, I guess for lack of a better word, we interviewed various law firms that might represent the city and the county, and then we filed a joint complaint against opioid manufacturers and distributors. After that, state government started to get involved because there were so many different lawsuits filed by units of local government. And a settlement was actually negotiated by the Attorney General's office in 2021. Many of you may remember that. It was negotiated right at the end of the General Assembly's legislative session. Local governments found out about the settlement agreement and its terms very, very late, and it contained an opt-out provision for local governments. And I know I think we were very public about this at the city of Bloomington, and I think it was a very common response. The terms of the 2021 settlement were not particularly favorable to local governments, and I think as a consequence of that, almost every single local government that was involved in an opioid lawsuit at that point in time opted out of that settlement agreement. I think that sent a pretty clear message to the Attorney General's office, and in 2021, they went back to the drawing board, worked with the General Assembly, and renegotiated the terms of the opioid settlement agreements. And in that case, the settlement terms were a lot better. We had a 50-50 split between the state and local units of government, and then we had a 30-70 split between restricted and unrestricted funds in the next settlement. So local governments started opting in. So the terms of those settlement agreements are governed by Indiana Code 4-6-15, and of course by the settlement agreements themselves. And so we had everybody opt in, and that's where we are today. Who is covered by the opioid settlements? Well, if we look at Indiana Code 4-6-15-2, all political subdivisions are considered a party to the opioid settlements unless they successfully opt out. To my knowledge, I don't know if there are any opt-out units that are left. It's funny because the 2021 settlement resulted in nearly universally units opting out, and then the 2022 settlement resulted nearly universally in units opting in, which is maybe a message about the difference between those two negotiated settlements. If there were any political subdivisions that opted out, did anybody here have an opt-out unit? Does anybody know? I doubt you did. If there were any units that opted out, they are not covered by the terms of those settlement agreements or by the rules in Title IV related to opioid funds. It would be a really tough case or a tough position to be in, I think, at this point, with the way this litigation has proceeded, to be a local government unit trying to do this all by yourself when everybody else has sort of opted to select the settlement agreement negotiated by the Attorney General's office. So I don't really think there are many in Indiana, or any in Indiana, really left. All right, so who receives settlement proceeds? Well, as I said, it's a 50-50 split under the terms of the 2022 settlement agreement, so 50% goes to the state of Indiana. They have the exact same formulaic distribution that local units do, the state of Indiana does. 30% goes to an unrestricted opioid settlement account, and 70% of the state's portion is placed in the state's opioid abatement settlement account, which is a restricted fund. So, of course, the state has sort of the same issues that we're seeing a lot of local governments have in terms of figuring out how to use this big pot of money that has some restricted uses attached to it. We've seen the state give a lot of its money to FSSA for various programs that are related to abatement. They've also funded the Indiana Commission to Combat Substance Use Disorder. Some of the things that commission has, some of the initiatives that commission has championed are to develop housing for people who are recovering from substance use disorder, naloxone distribution, so those sorts of things that we're seeing a lot of units do with those restricted opioid funds. The other half, of course, goes to cities, counties, and towns. Before I mention political subdivisions, not all political subdivisions receive opioid distributions. For example, townships are not going to receive a distribution. Under the opioid settlements, it's cities, counties, and towns. That's it. And they get 50% of the settlement proceeds. 30% goes into the unrestricted fund, so the fund number for that you should be familiar with is 1238, and 70% is placed in the opioid restricted fund. So when we look at the statute, you'll see the statute sort of break it down as 15 into the local unrestricted opioid fund, 15%, 15% into the state's unrestricted fund, and then 30% each into the state's and the locals' restricted opioid abatement funds. Local governments, as I said, other than cities, counties, and towns, do not receive opioid distributions, even though they are technically bound by the terms of the settlement agreement. So a township cannot file an independent lawsuit against any opioid manufacturers or distributors. There are a couple of unique rules that involve counties. Hopefully these are familiar to you. If a city or town is slated to receive an annual restricted opioid distribution less than $5,000, they do not get it. The distribution instead goes to the county. You may remember when this legal regime was first put into place, the number was actually a little bit lower. It was $1,000 that would have been distributed to the county if that's all a city or town was going to get during the course of a year. That was sort of a ridiculously absurd low number, in my personal opinion. I don't know what you would do with $1,000 of restricted opioid funds. You'd probably just try to give it away, because I'm not sure what program you're going to fund with that tiny pot of money. $5,000, again, this is just my personal opinion, but $5,000 still feels a little bit low. I don't know what you do with that amount of restricted opioid dollars. It's hard enough to find ways to spend sometimes bigger pots of money than that. So in any case, if the distribution is under $5,000 to a city or town, that goes to you guys, and you guys have to treat it just like a restricted opioid, just like other restricted opioid dollars. It does not become unrestricted when the county retains it. So again, we're talking only about restricted opioid funds. If you get only $1 as a city or town of unrestricted opioid dollars, you still get to collect those. Those do not go to the county. It's only the restricted dollars that would end up going to the county. All right, how often are opioid funds distributed? This is a great question. All we get from the statute is that funds received from opioid litigation settlements shall be distributed in a minimum of 2 payments per year. So you'll get at least 2 distributions per year. Last summer, I had the pleasure of sitting through a training session with the Attorney General's office on opioid funds and opioid settlements. In 2025, what they said at that point in time, and this was at the end of June, is that their hope was to do a July and a September distribution to locals. I don't know if that came to fruition or not. Is that what you guys saw, that you were getting distributions in July and September? Does anybody remember? In any case, that's what they were planning to do. They did mention that they were hoping to do at least one of the annual distributions, semi-annual distributions, in August or September of each year, but we'll see. And part of the problem here is that the Attorney General's office is not just sitting on a big pot of money. They get funds as they are paid out to the state of Indiana by the settlement administrator for the opioid multi-district litigation settlement. So those dollars come into the Attorney General's office, and then they go out to locals twice a year. But when those dollars come in specifically, and how often and how much, that's a little bit tricky to predict. So it's always hard to say how much those distributions are going to be. This is also going to last a long time, right? The settlement agreement that was negotiated between those manufacturers and distributors and various states says that distributions are supposed to continue all the way through 2038. So we've got 12 more years of distributions going forward. And those settlements, or excuse me, those lawsuits that we were talking about were filed, many of them, before 2018. So we're talking about 20 plus years since those lawsuits were originally filed before those last distributions are scheduled to be paid out. So money will be coming for a long time, but not for forever. Eventually it will stop. Do you have to accept your opioid distributions? This is probably less of a question that's interesting for counties than it is for other units of government. And the answer is no. You actually can receive your distribution and then transfer it to another unit of government and work together with that unit of government to benefit both communities, the community that does the transferring and the community that receives the funds from the other unit. And that's governed by Indiana Code 4-6-15-4H. So that's something you can work with local governments on, cities or towns that might be in your county. I think sometimes those smaller units, as I mentioned, have a hard time finding uses for the small pot of restricted opioid dollars they may have, and the county may actually be able to use them. We would recommend at the State Board of Accounts that if this is the sort of thing that's going to happen, and dollars are going to be transferred from one city or town to a county or to another city or town, that you document that probably through an interlocal agreement, right? Write down the terms, write down exactly the amount that's going to be transferred, work to work out all the terms and conditions that are going to be associated with one unit of government transferring its restricted opioid dollars to another in a written agreement. Our field examiners will love you for that if that's what you do. So that's the best way to do it. Restricted dollars are always restricted dollars. So if you take your restricted pot of opioid dollars and you transfer that to another unit of government for the benefit of both communities, and you document that in an interlocal agreement, again, those dollars don't magically become unrestricted. Once they're restricted, they're always restricted. So you still have to use them in accordance with the terms and conditions that are governed by the settlement agreement, which we'll see in a little bit. You can also sell your right to your future distributions. This is a really fascinating provision of this section of code to me, because it's so interesting that this is something you might do. But a city, county, or town can sell its right to receive an opioid distribution. So I started thinking about why you would do that, or the circumstances under which you would do that. If you had a big project that some nonprofit that was eligible to receive part of those opioid restricted funds wanted to do, there might be ways to sell to a third party the right to receive those future opioid funds and to use the proceeds to do a bigger project in the short term. You can also sell a security interest in your opioid funds, right? So I don't know if anybody would do that. Has anybody even thought about doing that at the county level? Yeah, I haven't heard anybody who suggested that this is something that a local unit of government might do, but it's there. It does require legislative body approval, so for most of you that means the commissioners would have to approve the arrangement to sell your restricted opioid proceeds, but it's something you can do if you wanted to. And again, as always, the proceeds from the sale of your restricted opioid funds would remain restricted, just like if you were receiving the distributions yourself. So it doesn't change the uses. Okay, so here are the really interesting questions. These are the things that people are emailing and calling about. For what purposes may opioid distributions be used? For what purposes may unrestricted opioid funds be spent? Boy, I hope this is easy. It's right there in the title. They can be used for any lawful corporate purpose of the county. So you want to buy squad cars with your unrestricted opioid dollars, go ahead and do it. No problem at all. If you want to pave roads, go ahead and do it. You can do anything you want to do with it. I think of unrestricted opioid dollars just like they're general fund dollars. right? They go in a different account, but they're the same. Same thing as general fund dollars. But again, remember, opioid funds have to be appropriated prior to expenditure. So you cannot spend them unless the county council gives you approval to spend them. And that's just the general default rule, right? No spending, no disbursement without an appropriation. Okay, now the even more interesting stuff. Restricted opioid funds, what are the permissible uses of those? So this is where we get into the interesting stuff. Restricted opioid funds must be expended in accordance with the terms of the negotiated settlement agreement. That is very difficult for me as a lawyer for the State Board of Accounts to get used to, because we are used to looking at state code when we're trying to figure out what the restrictions on a fund are. It's really strange for me to be looking at an attachment to a settlement agreement and parsing through dozens of pages of that attachment to try to figure out whether or not we have a lawful expenditure. But that's what we do with these particular funds. Exhibit E of the settlement agreement that was negotiated as part of the settlement of the multi-district litigation, the MDL litigation, contains the limitations on uses. I have the link there. It is a long document. It's broken down by category. Hopefully this is something that you have seen or thought about, or your lawyers have seen and thought about for you when coming up with ideas for how to spend opioid abatement funds. It is pretty limited, so do take a look at that when you have an opportunity, just to familiarize yourself with the requirements for spending restricted opioid funds. One thing that has come up, we've gotten a couple of questions from people at the local level wondering whether or not they're required to set up a local committee to make recommendations on how to spend restricted opioid dollars. And the answer is no. You don't have to create a committee at the local level to do it. That is something that we have seen a number of communities do. I do personally think it's a good idea to set up a committee to think about ways that your community might use your restricted opioid dollars that both benefit your community and also are in accordance with the terms of Exhibit E of the settlement agreement. So that's something some communities are doing. There are lots of different ways to set up that type of committee, but that's something you might think about if it's something you haven't thought about before. I know in the training session that I attended last June with the Attorney General's office, that was one of their recommendations. They really liked the idea of local units of government setting up committees to think about ways they might spend their restricted opioid dollars that is compliant with the terms of the settlement agreement. Okay, so I put a few examples into the slides of ways that, how do I say this, maybe some things that we have seen some local units of government do. Nobody's going to name any names, just to go over what may and may not be permitted under the terms of the settlement agreement. So substance use provider workforce training. So training for those individuals who are on the front lines of helping people recover from opioid substance use disorder. You think that that is a permissible expenditure of restricted opioid funds? Yes, I heard somebody say yes. I know I won't make you participate too much. It's just fine. Yeah, that one's pretty straightforward, right? That one's really easy. Providing training and harm reduction strategies to healthcare providers, students, peer recovery coaches, recovery outreach specialists, or other professionals that provide care to persons who use opioids. That language I pulled directly from Exhibit E of the settlement agreement. This is exactly the sort of thing that I think all of the attorneys on both sides, on the plaintiff side and the defendant side, had in mind when they set aside this pot of money for local communities to recover from the adverse impacts of the opioid epidemic. All right, some more specific examples. Naloxone distribution projects. Again, I'm not even going to ask. This is so easy. The answer is yes. This, again, is exactly what everybody had in mind. Naloxone, of course, is the drug that's administered to counteract the impacts of somebody who may be having a medical emergency associated with opioid use. Again, I pulled some language directly from the settlement agreement. I pulled two different bits of language here. There are so many more that would support this particular expenditure. Increased availability and distribution of naloxone, increased naloxone distribution to individuals who are uninsured or whose insurance does not cover the needed service. These sorts of expenditures are exactly what everybody had in mind. And again, directly from the settlement agreement, that language comes out of. How about body cameras for law enforcement personnel? Do we think that this one would be a permissible use of restricted opioid funds? try to make one of these more interesting examples. Probably not, from my perspective. So I don't see anything when I go through the very long document that is Exhibit E to the settlement agreement. I don't see any language that directly supports the purchase of body cameras for law enforcement personnel. Again, when you're thinking about a borderline use of restricted opioid funds, look into the agreement and see if you can identify some language directly in Exhibit E that supports that particular use of those restricted funds. Are you able to identify something in the settlement agreement that says you can use it for that purpose? When I look through it, I don't see anything that would support the use of funds to buy body cameras for law enforcement personnel. Now, you may look through it, your attorney may look through it, and think you identify something that permits that sort of what I'm going to call a borderline use of restricted funds. If you see that, write it down, document, cite precisely what you think in Exhibit E supports the expenditure for those purposes. And again, I see some faces. We're not trying to scare anybody here or anything like that. But if you're seeing these types of expenditures, or if department heads, if sheriffs, if others in the county are coming to you and saying, oh great, we have this big pot of money and I've got this really creative idea for how to use it, make sure you say to them, look, what in Exhibit E supports that use of these restricted funds? Let's write it down, let's document it to make sure we're all comfortable that this is a permissible use of restricted funds and that the State Board of Accounts isn't going to come in after the fact and tell me that I used the funds in a way that I wasn't supposed to. All right, how about youth opioid education? Again, should be super, super easy. Yes, of course, providing education to school-based and youth-focused programs that discourage or prevent misuse. So if your county has something like, I'm a child of the 90s. I don't even know if this is something that we still do, but if you have a DARE program or something like that, these are the sorts of programs that are perfectly exactly what everybody had in mind when they negotiated the settlement agreements. If your county supports those types of programs, those are the sorts of things you can do with restricted opioid funds. Youth-based education. All right. How about vape sensors in county facilities? I'm hearing some no's. So I'm hearing some louder no's. Yeah, I think that's right. Probably not. Again, I'm going to write these same words over and over again in slide after slide. Are you able to identify a portion of Exhibit E to the settlement agreement that supports the use? If you are, what portion of that settlement agreement is it? Write it down, quote it, cite it. That's going to be sort of the go-to document that everybody's going to look at when they're looking for some support for a permissible use of restricted opioid funds. Again, for vape sensors, when I look through Exhibit E, I don't see anything that directly supports that type of expenditure on a facility. So that's a tough one. All right, how about overdose data collection and analysis? Hiring a third party to analyze where overdoses are happening, where public safety officials are using naloxone, how much they're using, how fast they're going through it. I think that's an easy yes again, right? Expanding, improving, or developing data tracking software and applications for overdoses and naloxone revivals. This is right out of the settlement agreement again. So if that's something you're interested in figuring out, tracking data, figuring out where you have misuse, whether or not your strategies for combating opioid misuse are working by collecting data, that is exactly the sort of thing that you can do at the county level that's exactly the sort of thing you can use your restricted opioid funds at the county level to do. How about rifle suppressors? Again, maybe that's the easiest, probably not example. Yeah, again, these are things I've found, again, not naming names, but these are questions that have come up from officials. I'm suspecting that this one maybe was an easy, probably not, even at the local level. Again, are you able to identify anything in Exhibit E that would authorize using restricted opioid dollars to purchase rifle suppressors? No, that's easy. Easy no, definitely not. So again, public officials, local officials, when they're not accountants or lawyers, love to get creative when they see a big pile of money in terms of spending it. They get really excited, and it's really just the accountants and lawyers who come in and say, well, there are some rules about how you spend that. So in this case, rifle suppressors is not a permissible use. What about AEDs? Now, this one to me is a little bit closer, and interestingly, again, I mentioned the training session I went to at with the Attorney General's office last year. This was an example that they cited directly for us as being a probably not, because that to me is the sort of thing that maybe is a revival tool for situations where you have somebody who is experiencing a medical crisis. But in fact, this one has been answered by the Attorney General's office, and they are a higher authority than the State Board of Accounts when it comes to these settlement agreements. And what they said is no. So that gives you a sense that sometimes they're going to be pretty particular about what is a qualified expenditure for opioid-restricted funds. So I don't know. Did I see a hand briefly over here? No? Okay. So yeah. So that one's been asked directly. AEDs has, and it's been answered with a no directly. So, and not by the State Board of Accounts, by people who are not us. But obviously, we'll listen to the Attorney General's office when they give us guidance. So, okay. So oversight of restricted uses. This is where we get into some really interesting issues. Restrictions on the expenditure of opioid funds are imposed through a settlement agreement, right? Through a settlement agreement, not through a statute, not through a uniform compliance guideline, which is where we're used to seeing restrictions on uses documented. So this is really new for me. I think it's relatively new for Stacy even, and she's been around the State Board of Accounts for a really long time. We're not used to looking at negotiated settlement agreements as part of litigation when we're sorting out whether or not a local unit of government is spending money lawfully. So that's very new for us. And that sort of puts us in a unique position because we have this settlement agreement that was negotiated by the Attorney General's office. But then we also have Title IV, where the terms of those settlement agreements are sort of kind of documented by the creation of these two funds, the unrestricted fund and the restricted fund. And so our role is a little bit unique when it comes to opioid restricted funds. It's really a blended approach. We have this statute that we're used to being the final authority in terms of giving guidance on, but then on the other hand, we have this settlement agreement that the Attorney General's office really negotiated and is responsible for making sure the terms of it are complied with. So, there is a chance if you call us up with a really tricky question about whether or not you can use restricted opioid dollars in a particular way, that we are going to seek guidance from the Attorney General's office, because there is more at issue with this particular pot of money than just whether or not we're going to issue some sort of audit finding if it's spent incorrectly, right? If local units of government are not spending the restricted opioid dollars in accordance with the settlement agreement, really what that could do ultimately is jeopardize the terms of that settlement agreement. It could put those future distributions to your unit and to other units in the state of Indiana on the line, right? If somebody were to say, one of the defendants to the lawsuit were to say, look, we negotiated this very detailed settlement agreement and the plaintiffs are not complying with the terms and provisions that we negotiated with, that's a situation where a court ultimately could step in and say, look, if that's what's going to happen, the terms of the settlement agreement are going to be altered or they're going to be nullified. So it's a little more complicated than what we normally deal with when we think about enforcing the terms of a negotiated settlement as part of litigation. So that may happen if you reach out to us where we say, look, we want the Attorney General's guidance. And I mentioned that already, right? When it came to AEDs, the Attorney General's office has issued guidance on whether or not that's a permissible use. So the State Board of Accounts role is a little bit different than what I'm accustomed to. It makes me a little more uncomfortable, makes me a little annoyed that I have to seek somebody else's opinion before I can give guidance, but that's the reality when it comes to restricted opioid funds. Okay, last slide here. There are some reporting requirements. Look, these settlements were negotiated in 2022. Reporting requirements, I think, began in 2023, so you should have been doing reporting on this already. If you haven't been, then you haven't been doing the right thing. I'm sure that all of the counties have been doing the right things. Sometimes some of our smaller cities or towns have trouble with this. But under Indiana Code 4-6-15-4, entities that are receiving opioid settlement funds have to monitor the use of those funds and provide an annual report to the FSSA. Under code, FSSA has to provide that annual report to the General Assembly by October 1st. That means that everything starts in motion hopefully around the beginning of August. FSSA uses Aegis Group right now to distribute a link to local units of government. I assume that goes to your individual auditors' offices. That's what I would guess, at least, to figure out how those opioid restricted funds are being used. And then usually they set a deadline sometime around the beginning of September for the use of those, for the reporting on how you have used your opioid funds from the previous year. I think those reports, I don't know if everybody's aware of it in the room, but those reports have generated a fair bit of attention in the media. I know that if you just Google a couple of news articles related to opioid restricted funds use in the state of Indiana, you're going to find some reporting on this. So that's a way of saying, at least at this moment in time, the use of these funds is a little bit under the microscope, which means that all of us, both at the State Board of Accounts and at the local level, are going to be under pressure to make sure that we're looking at how these funds are used on the front end, in addition to how they're reported on the back end. Again, journalists are watching this for the moment. I haven't heard any talk about the settlement administrator being interested in this on any level or any of the defendants. But again, this is something that does get a little bit of attention, so be mindful about the uses of these funds. If you have grumpy sheriffs or other folks who really want to push the envelope on the use of these funds, feel free to say, look, people are watching this closely, right? This is being reported on, and we don't want our names in those reports. So let's do it by the books. Let's find some language directly in Exhibit E that supports every expenditure that we're making out of these opioid restricted funds. Okay, so that's all that I have for you right now. If people have questions, there is a fair bit of time for me to answer any questions you might have.
Don't worry, Mike. I have questions.
Oh, great.
For you guys.
Wonderful.
Oh, pause one moment. I have a couple things. Okay, the first question that everyone kept grabbing me for was, am I going to get this PowerPoint? Yes. It's Mike's fault I didn't have the PowerPoint. I'm just kidding.
No, it is completely my fault.
It's his fault.
She's right.
Okay,
No,
we're going to take ownership here. It's Mike's fault. Okay, he's owned that. It's on recording. That's perfect. But no, what I'm going to do is we have been behind, so I took all the PowerPoints that I had ready, and I was like, they want them, so I'm going to get them out. Well, we missed a couple, so that's okay. I'm going to send, so how many of you were subscribed to our emails and actually got the presentations via Microsoft Cloud? Okay, how many of you didn't get them that way and then had to get them from the association? Okay, a couple. So that's the big thing is with ADA compliance, I can now not put PowerPoint presentations on our website. I know, gasp, it's terrible. Recorders already told me about it. So I was like, this is what we're gonna do. We're gonna be sending them out via email, so please, please, please subscribe to our Microsoft Cloud notices. That's how I'm gonna be sending out all PowerPoint presentations. So I will be sending out one notice to you guys like I do normally to say, hey, here's the agenda, here's the call letter. The second one I'll be sending out will be a week before conference, and it will say, here's the agenda, here's the call letter. By the way, here's all the PowerPoint presentations I have right now. Sorry, Jackie, is this better? Okay, and so make sure that if you were not subscribed, we get subscribed, because then that way you guys are getting the emails. The third email I'm going to send out is after conference. I'm going to make sure that I get everyone's PowerPoint presentations, and I'm going to send one more last email out saying, here's all the PowerPoint presentations from conference, and then that's where I'm also going to put the Q&A that you guys ask. So it's not going to appear in the bulletin anymore, okay? So the Q&As from conference will be sent with all the presentations at the end, and it'll say, here's all the questions and answers from conference, okay? So it's going to be like one giant packet sent to you guys of all conference materials, okay? If we don't like it, we can work through it, but this is what we're going to do right now, okay? So you guys will get that PowerPoint presentation. How do you get access? You go to our website. Mike, go to our website. Sorry. Mike, would you please go to our website? Sorry, I apologize. He's up there, so I'm just going to make you do it. So, escape.
Oh.
Escape. See, he's like, no, you're joking. No, go to the website.
Why is it not escaping?
Oh, is it locked? See, we broke it. Okay.
Did I break it?
You probably did. Unplug and then see if it'll go away.
Okay.
Why he's trying to do that, we'll just demonstrate how you subscribe to our emails because some of you are not subscribed. And so you're missing stuff from me and Mike, and that's sad. You love us. I know that, okay? So while Mike's trying to get that up, we'll digress. Oh, look, okay.
It doesn't want to go.
It doesn't want to go? That's rude. What is it doing? I'm disappointed in Michael. No, I'm just kidding.
My desktop.
See, guys, you guys are going, oh man, Ricky's not here anymore. This isn't going to be fun. And I'm like, nah, it's fun, okay? Because my favorite thing is...
let me see if I can figure it out. Keep talking.
Mike's like, I'm going to get this, okay? Because you guys go, there's not going to be that banter anymore. No, there is. And Mike is a real good team player, and he does dish it back, okay? This is just day one, okay? But the thing is, he doesn't know what I'm going to say. So for him, that's scary because I could say anything. You got to know that. But I'm being recorded, so I'm not going to, Jackie, okay? If so, I'll be like, please remove from said this time and date. No, but as Mike tries to figure that out, if you guys find a different way to get PowerPoint presentations and materials, I'm totally up for any ideas that you have because this is all I have. ADA compliance has really cramped my style in a lot of ways because it's taken a lot of stuff off of our website. And I will talk about our resources because a lot of them have changed, okay? While he's still trying to get that figured out, which I believe in you, okay?
You want to try should we switch it?
Oh, it doesn't matter. Okay, here, we're switching. One moment. See, you guys just wanted me up here. This is what it was. Okay, Jackie was irritated with me moving, and so here we are. Okay. Right? And I have a good suit on today. I have a good hair day. It's a thing.
What are you saying about me?
Your hair is beautiful, Michael. But see, I think he always has it's like the same hair every day. And some days I'll have to say, Michael, I'm so sorry for my appearance. And he's like, don't apologize. And I'm like, I look rough today. So hold on. Let's see. Watch me not be able to do it. This will be fun, okay? It's a test. Dude, it's going to do the same thing to me. I dude Michael a lot. Yeah. We're not going to extend. We're going to duplicate. This should fix all my problems. Okay, you guys can now see what I'm doing. Okay. Oh, no, not the snipping tool. That's not what I wanted. We want to open up your web browser. And you want to go to our website. What the heck? Guys, I just had this signed in. Why did it kick me off? This is rude. Here, hold on. Connect. And it's Indiana 26, right? Before I shut it, it was all red. Okay, here we go. Okay, so you're on our main web page. And what you're going to want to do is you're going to want to scroll down. See this little bitty red button? Yeah, you want to find that red button with the exclamation point, and it says subscribe for email updates. Okay, I know you're going to be surprised because you have to click something else again, okay? So you're going to click here. You're going to open it, and then you're going to fill out this pretty little form, okay? And then it will direct you to another page. I'm not subscribed, so because I send the notices. I don't need to be subscribed. So I'm not going to show you how to do it. But after you fill out your name and your county, then you're going to be going directed to another page that says, what do I want to hear from? Do I want to hear from clerks, auditors? Like, what type of do I want? Type of offices. Words today are hard. But you're going to pick that. I have noticed that some people, when they do subscribe, they subscribe for all the offices. Don't do that, okay? Because again, if you subscribe to clerks, you're gonna get their call letters, conference information. I mean, you can, but that's a lot of emails. So your inboxes are probably really full. I wouldn't advise doing that, okay? But you guys know how this is how we send out bulletins. This is how we send out state examiner directives. This is how we send out all the things. So subscribing is super duper important since some of you guys aren't getting some of the information, okay? So now that we got that ironed out, I want to talk about, I'm gonna throw up the QR code because a lot of the stuff I have to talk about really has nothing to do with Mike's well, it has everything to do about Mike's PowerPoint presentation, but I don't need his PowerPoint presentation up, okay? So, my questions for you guys. How many of you have established a committee at your county? Okay, yes. And you guys have established policies and procedures in place to distribute these funds? Because how many of you are actually keeping all the money and spending it yourself? How many of you are actually doing that? Okay, that's what I assumed. A lot more of you, though, are not. How many of us are distributing everything that we're receiving because that's easier? So you guys are all holding your money. Come on, guys. I need something from you. You're doing both. Okay, you're doing both. Because I think, Paula, you reached out to me at one point in time, and you said that you were actually distributing to some departments in your county, but then you also grant funds to other entities. So we have a third bucket. How many of you are doing that? Okay, a lot of you are doing that. Okay, so whenever it comes to your guys' agreements that you guys have in place, in our agreements, are we establishing monitoring procedures to make sure that the funds are being spent appropriately? Yes, just loudly, yes. Yes, Stacy, okay. Because, again, like Mike kind of alluded to, there are some instances when you give the money to somebody, but you don't know how they're spending it. The only way that you know that it's in compliance with that settlement agreement, because Mike said, hey, this is different than what we normally see. Normally, we have statute to say, hey, these are your allowable uses. That's within our realm. But being that this is a settlement agreement, we're having to look at additional documentation where where it's a weird situation, like Mike said. If we don't know how to interpret Exhibit E, and it's not clear in there, your best thing to do is to ask the Attorney General's office. And if you have that documentation saying that it's an appropriate use of those funds, that's great. That's great audit documentation, okay? But I want you guys in your grant agreements to make sure that you have monitoring procedures set in place. So even if it's, hey, after you've spent the money, show me what you spent the money on. How many of us have actually went to that extent and have people that are doing monitoring? Okay, I love that because this is a big pot of money. And the question that I feel like we have is, what happens if these funds are not spent in compliance with the settlement agreement? That's kind of what Mike brought up, like one of his last points, like what happens? Well, we would obviously, if it comes up during audit and we see it, we could write it up for noncompliance with the settlement agreement. However, there's that big what if of what happens after that. If you are not in compliance with a settlement agreement, that's different than not being in compliance with Indiana code, okay? There's two sets of noncompliance here. One of them, you're in noncompliance with a court order. And this is the agreement, this is the settlement, this is what they said these monies are going to be used for, okay? So this is a very beginning phase of all of this where we're starting to see like us auditing the funds, seeing things that are considered not compliance, but we don't know what the end result will be. We don't know if you just pay back the fund and it's fine. We don't know if we find out that there's noncompliance with a settlement agreement, then you have to pay back all the monies. We don't know. So that's why it's very important whenever we're monitoring these monies and giving these monies away to another entity to spend, that you have some type of procedures in place to make sure they're spending it appropriately, okay? Because whose fault is it if they spend it inappropriately? The question is, well, the county never followed up. Well, did the county know what they were spending it on? Yeah. They could tell you, I have this project, and this falls completely with Exhibit E. However, you gave them the money up front, then they go over here, and they're like, no one's going to know that I took all these people out for dinner because they're not looking for that. That's what I don't want to happen, okay? I want you guys to be very prepared to be able to say, if someone comes asking you what these monies are being used for, you can say, this is what they said they were using the money for. I ask them quarterly to send me expenditure reports. I review those and all the supporting documentation, and I'm monitoring and seeing what they're doing. That's a beautiful answer. Because you are trying to do what you can within your powers to make sure that money is being spent appropriately, okay? Again, those are just ideas, but I want to make sure that we understand that these monies are very different, and there are a lot of questions around them, okay? So there was just a lot of chatter out there whenever Mike was up here. And I love seeing you guys like whispering to each other, because I don't know if it's what about Mike's talking about or if it's something like, what are we having for lunch? I don't know what it is. But do we have any questions? Because now's the time to ask them. Oh, bless you. Questions, comments, concerns? Oh, sorry, Kelly. I forgot. I got distracted. You're number 2.
Oh, sorry. Our county opted into the 6 remnant defendant opioid settlement.
Yeah.
I think we were already talking about this, but
Yes.
I didn't know if you guys were going to have the same set of rules.
Well,
for those.
it's how many other counties have actually opted into this 6 remnant? Okay. Mike and I have actually been talking about this, and I have no idea if Mike has come up with like an epiphany since last week regarding these funds.
No, we don't have a clear answer at this point in time. What we do know, or what I think we can confirm, is it's not part of the broadly negotiated settlement agreement that's going to create this $50+ billion pot of money. It's outside of that context in terms of what the rules are associated with that fund, whether our agency would be involved in dictating how those expenditures are going to happen on any level. Those sorts of questions are really interesting. This is really a new thing, and I don't know if everybody knows about this, but this is sort of a separately negotiated piece of litigation with other opioid manufacturers and distributors that was not part of the broader settlement agreement. The overwhelming majority of settlements are part of this framework that we have in Title IV, but in terms of how it's going to work for local governments that are entitled to a distribution under this separate settlement, we don't have answers for you yet. But stand by. We know that these questions are coming up. It's hot off the presses. I think this was negotiated maybe even just very, very recently. So we're working on getting guidance.
Have you guys received the funding yet, or just opted into it? It's coming in June or July? Okay. So Mike and I, we are working on it. I don't know, was it you that sent us the email and asked? Okay, and I was like, hey, I got to talk about this. Because I was like, Mike, what is this? We need to discuss. If you get it before we make a determination, which I hope we do, before you get the money, put it in a separate fund. So when you're thinking about our chart of accounts, I don't think it's going to be a statutory fund because it's a settlement agreement. I don't think it lives in federal because it's not federal money. I don't believe it lives in state or local grants either. I would recommend possibly a home rule fund. That's the safest place that you can put the money right now. And if some guidance comes from them later saying you can deposit in general fund and you can use it for whatever you'd like, any county business purpose, but I would recommend keeping it separate when you get it. Yes, I don't think it's going to be a statutory fund because it's different than the opioid settlement money. They're just different. I would recommend naming it something, making it very clear, setting up a home rule fund, but I want to get you that guidance in writing because I want to make sure it's not we don't think it's part of this money, so it's not going to be statutory. It's completely different funds. So if you find out that it's like state or local money, which I don't think that it's going to fall into that. I don't think it's going to fall into federal. Home rule's the safest place right now for it if you get it. So, okay. Kelly. Don't forget about Kelly. Oh, same question. Okay.
I was uncomfortable telling our commissioners to go ahead and sign up for this. So I was really curious, Do you know how many hands went up when they said they did it?
There was only like 5 I saw. Can you guys,
I
whoever
thought less than
has
6.
opted in, okay, there's way more. So it looks like there's several other counties. Did you get them, or do you want them to raise their hands
No,
again?
it's okay. I can just throw a number out there now
Okay.
if it was more than that. But yeah, I wasn't sure what to do with it, how to report it. Can we spend it on anything? So that was my question.
And we're
as
still
well.
having to do some digging on it. So whatever we do find, we will try and get you. I'll add this to our Q&A for conference, and hopefully we have some guidance before conference ends. Michael loves when I give him hard questions, and I'm like, figure it out. Let me know. That's typically how it goes with the fingers and everything. I'm like, let me know, and then I just exit stage right, you know. But we will try and get you that in the Q&A.
And the list of units in Indiana that signed up, counties, cities, towns, it's a long list. So this is a question that we are going to have to answer for multiple types of units.
Yes.
Not just counties, and there are
Yeah.
a lot of units that opted in, so this is something that you will hear from us about for sure.
Definitely.
And it is just what makes it a little bit different, right? I mean, negotiating settlement agreements as part of litigation and then having some restrictions on what you can spend those settlement proceeds on, that's really not unheard of. What's unusual about this is it's so many different units of government that are involved in this settlement, so.
Yeah. Mike, you got, oh.
I have it pulled up. They extended the participation date out to June 4th. It was in May.
Okay, so extended until June 4th for participation. Okay.
So the list may grow, I think is
Yeah.
what you're saying there.
Okay.
So yeah.
Mike, there was one back row.
Okay, so still being pretty new to this whole process, but just checking. So we have different organizations that'll come in and present to the commissioners on their opioid settlement funds, and the commissioners will decide how that's going to be dispersed. The treasurer and I, like the treasurer, will invest that opioid money and has. My question is, and it seems like every time we get ready to pay out this, like they say how much, but then our money runs also through the community foundation. So we're thinking like the community foundation should always give us the claim for us to pay that money out. Is that correct?
So you guys have partnered with the community foundation. I'm assuming that there is a contract in place.
I think so, yes.
Okay,
ma'am.
so you maintain the money on your ledger. However, the foundation is spending the money. They submit a claim to you for, is it reimbursement or is it for you just to
pay out of the opioid funds, what they've decided to pay to each entity.
That is fine, because it sounds like you have an agreement in place to do that. Mike, correct me if I'm wrong. I don't see any issue with that, because you would then be auditing the claim to make sure that it's in compliance with the settlement agreement.
Yeah, my only problem is that when they decide to pay it out, then they totally forget that they're supposed to submit the claim to us to pay it out. So then it's like, they think we're supposed to do it, but we're not. But that's correct, right? Like
No,
they
yes.
have to give us the claim for us to pay that.
If that's how you have set it up to work, because most of them in this room, I think, are probably doing a lump sum to an entity to then spend down, kind of like an advance grant. What you're doing is more so kind of just keeping the funds, making sure that you're auditing them beforehand, and that's what your agreement puts in place. So there's no issue with that at all. No.
Okay, but they have to give us the claim for
They have to give you the claim, because you don't know something needs to be paid. If in that agreement, they're the ones making the decisions over the money, in a sense, your agreement should put that in place to say, this is how you're going to file claims so that they can be paid, and then go forth.
Thank you.
Okay, I don't know. I have 3 minutes. Does anyone have anything, or do you guys want to go downstairs and get in line for lunch? The latter, right? Okay. We will adjourn and be back at 1 o'clock, and please make sure you scan the QR code.